And now questions from the committee. A major failure of the U.S. immigration system is the failure to consider the fate of the children of temporary visa holders. While their parents have applied for green cards, applications remain stuck in years-long backlogs. There are currently over 250,000 children of long-term temporary visa holders who are at risk of aging out from the protection of their parents' status. These are individuals who, like Ms. Rajakumar, have grown up in the United States, have contributed greatly to their communities, and who are unmistakably American. For these documented dreamers, as they're called, there are almost no pathways to remain in the country after aging out of their parents' visas. So when they turn 21, they face the impossible decision of leaving their families to return to a country that is often completely foreign to them, or living undocumented in the shadows. I introduced the bipartisan America's Children Act, which would create green card opportunities for these children and fix this often overlooked inequity in our immigration system. Ms. Rajakumar, again, thank you for sharing your story with us. And if I may, can you explain how the enactment of the bill, I know you're familiar with it, how it would impact your life and what having a pathway to citizenship would mean to you?
First and foremost, what comes to my brain is that my mom and I would not be immediately separated. But second, it would allow me to pursue my desired career path, gain experience. And while these are tangible things I can point out, the biggest thing that it would do is allow me to build my life here permanently and contribute to the place that I've called home for 20 years without fear that it would be taken away from me.
Thank you. Second question is for Mr. Melmond. Do you think it makes sense for our immigration system to allow children to be brought here on their parents' visa, raised and educated here, oftentimes for decades, but not have a clear opportunity to become an American citizen because their parents' green card petition is stuck in the backlog?
Chairman, it doesn't make sense. If I could add a couple additional points to that issue is that.
So make sure your microphone is on.
Chairman, it doesn't make sense. And if I could add additional points to that question is that the backlog that they are experiencing was not contemplated by Congress previously. Backlogs are not new to the immigration system. You can say, in fact, that the 70 years ago there were backlogs in the immigration system, and Congress has on multiple times enacted relief for children who are aging out. But this particular group that Ms. Rajakumar is part of was not considered because those backlogs didn't exist at the time that Congress previously considered this issue. The second very sympathetic factor about this situation that they encounter themselves in as part of my testimony is these backlogs didn't exist as recently as 2013. So at the time that the parents entered the country on the temporary work visas, it wasn't like they could have known, none of us really necessarily foresaw the explosion in those backlogs over the ensuing decade. As I did mention, Congress has wrestled with this issue before. There's been various policy solutions, including in some situations freezing their age, and other times using a formula to back out agency processing times to afford relief. So there are a few options for Congress to consider to provide relief, and they can look at prior legislation perhaps as a roadmap.
Share your observation, not just on this particular dynamic, but more broadly. And what's clear from today's testimony is that our immigration laws are outdated and no longer serve the purpose for which they were created. Now, reforming our family, employment, and diversity visa systems would be in the best interest of our economy and our communities. Professor Lagomsky, in your testimony, you highlighted several ideas to help reform the system and reduce the harmful backlog. I'd like to ask specifically about the idea of reclassifying spouses and unmarried children of legal permanent residents who are applying for family-based green cards. Right now, those individuals are subject to the arbitrary numerical limits, but your suggestion would be to classify them as immediate relatives, a category of relatives that is not subject to the numerical caps. So, Professor, can you explain why you believe a fix to this category of family-based petitioners would have a significant impact on reducing the backlog?
Thank you, Mr. Chairman. I think my strongest reason for feeling this would be a good fix just focuses on who these people are in reality. As I mentioned during my original remarks, these are people who petition for their spouses or for their new spouses or their newborn babies sometime after becoming an LPR. I should explain that if you are admitted as an LPR, the current law does allow you to bring with you your accompanying spouse and underage 21 unmarried children. The problem is that if you immigrate as an LPR and then you get married to someone who is not a citizen, or then you get married to someone and have a baby overseas, those children and spouse fall into the 2A category rather than the accompanying category. And although there currently is no wait, as I mentioned, there were very long waits before. The reason I focus on who these people are is that because the petitions are filed typically soon after the event, we are talking about separating newlywed couples and separating parents from their newborn babies for the first several years of their lives. And my guess is that people of all political stripes would recognize this to be a serious problem, a particularly heartbreaking one. But there are a couple of other practical reasons as well. One is that since the family members cannot come here until their visa numbers come up, if the LPR wants to maintain any semblance of a family life, what that person is going to have to do is periodically and frequently travel overseas to visit his or her family members, often at great disruption to the person's job, often at great expense. And thirdly, and I know this will be a little more controversial, it seems to me that when the waits do become this long, you're practically inviting illegal immigration. I want to be clear that I'm not advocating illegal immigration. I'm simply calling attention to the reality that human nature will have to be remade before newlywed spouses willingly separate for years at a time at the beginning of their marriage. Human nature will have to be remade before parents willingly separate from their newborn babies for the first several years of the child's life. My guess is that most of us in this room would not do so. And so these are particularly compelling circumstances for the family-sponsored 2As.
Thank you. Senator Cornyn.